Great. Hello, everybody, and welcome to the Beverly Hills Bar Association Immigration Section, CLE, a primer on U.S. Non-immigrant work visas for foreign workers. And we're so happy that you're here. My name is Maggie Stewart. I'm the co-chair of the Immigration Section, along with Joanne Litt. Before we get started today, I just want to let everyone know that our next section meeting is going to be on Friday, May 13th, and we're going to have a special day. We're going to have a gathering at Huntington Garden for a walk and then a lunch together. So if you'd like to join us for an in-person networking event followed by our section meeting, please watch for the invitation that should be circulated soon for that. And we're here for an hour, so I'm going to turn it over to Joanne Litt. Please don't forget to collect your CLE certificate. It will be in the BHBA portal when we're finished. Thanks all for joining.
You're muted.
Yes, sorry. Thank you everyone for coming. And today we are very, very fortunate to have Mr. Fabricio Lopez joining us to give us this very timely and educational discussion on non-immigrant visas and working in the US for foreign workers. And Fabricio is the adjunct professor of ethical lawyering and business immigration law at Loyola Law School and in-house counsel of a multinational entertainment company, which we can all, I think enough of people know which one it is, the one with the ears, and in the fight with Governor DeSantis right now. So, you know, draw your conclusions. And with that, Fabricio.
Hi, everybody. Thank you so much for the intro. And thank you all of you for joining us in a beautiful spring day in Los Angeles, where we're broadcasting here. So thank you for joining us today. I'm Fabricio, and what I'm getting my presentation on the screen, if you can please run that survey that I asked you to put together. Takes a second if you guys can respond to these questions on the screen. That would be really helpful because I want to get a sense of how much do you know about immigration law, because we can go really deep on these topics. You can have me here talking for all weekend, but we have only 1 hour because I love this subject matter. So it's really fun. Oh, this is so cool. I can see how the numbers are showing up. Let's see. Okay, it's changing. So a lot of you introduction, some of you familiar, few of you experienced, everybody, a lot of people here to have fun. That's good. I like that. Okay, very helpful. Let me keep that on the side so I can keep an eye on that. Okay, just a balance group. So here's what I'm thinking today we want to talk. First of all, a couple of housekeeping items. I already shared with you, you have a nice handouts, and also I give you a copy of the presentation so you can relax and watch this. And you can have the handouts too that I put together. I selected a lot of things that I thought will be interesting in this topic. So here's my plan for today. I want to talk about all these things that you see on the screen, and I want to focus on entertainment because after all, this is the Beverly Hills Bar Association and I'm broadcasting from Agora Hills, California. So I'm going to be focusing on entertainment. There's a lot of more things on immigration law that, you know, we can talk about. If you want to reach out to me later, I can talk to you. I can share some additional materials and all that. But my focus today will be on these topics because I think that to get an understanding of immigration law, these are things that you have to keep in mind. And I want to be focusing on entertainment. So that is kind of what my plan for today. So hopefully you walk out of this meeting with more understanding of this. So let's start with the big picture here that I think is important, is the background of our US immigration law system. So how is our system? The features of the system are, and these are a few of those, there are many more, but these are the ones that I think are important. Number one, we have a system that is sponsor based. What I mean by that is that our system, and again, actually, one thing I want to tell you, as with anything on the law, there's always exceptions. So generally, we have a system that is sponsor based. What that means is that if you're coming to the United States and you are trying to get a work visa or a green card, for example, generally, you're going to have someone else, an employer or a relative in the case of family immigration, who will have to petition you and serve as your sponsor. So there are some exceptions to that rule, but the general rule, you have to have someone to petition you to get a work visa or to get a green card, for example. The second one characteristic of the system is that once immigration gives you authorization to work in the United States, then there are some limitations. One of those limitations is that generally you can only work for the employer or the sponsor of the visa. So you may hear someone who says, I'm here based on a visa that my employer, Apple, got me to work as a software engineer. Can that person take that visa and use that visa to work for Google? Probably the answer is no. Why? Because that visa is employer specific, allows that person to only work for that employer. There are exceptions to that. I'm going to talk about one particular one that I think is really interesting in our field. The next characteristic of immigration law is that it's also employment specific. Let me explain what I mean by that. Once immigration gives a foreign national approval to work in the United States, that approval is conditioned on the fact that the person will be working only on whatever that visa petition said the person was going to be doing. So if you tell immigration, I want a visa for someone to work as a software engineer or as a director or as an actor, and the person calls you later and says, lawyer, I really meant to tell you that in addition to working as a director, I like to write and I like to executive produce. That means that you probably will have to go back to immigration and ask immigration to approve that additional employment because the initial approval was only for the purpose that you explained in the petition. Now, one thing to keep in mind here, and this is something that to me is so important, that is why we really need good immigration lawyers who know what they're doing and understand the needs of their clients and the purpose of the visa. Think about this. You as the immigration lawyer, you are in control of what are the conditions of employment because that will be determined by how you describe the job in the petition that you filed. So that to me is so important to keep in mind because that means that your communication and understanding of your clients' needs is critical. So talk to your clients, ask questions, what exactly are you trying to accomplish here? Are you going to try to work as X or Y? Are you considering maybe working on this other thing? Talk to your clients, get an understanding of what they need, and then make sure that you prepare that visa petition appropriately. So those are three characteristics of the system. Next thing here, concepts. These are two main concepts that I think are important to keep in mind as we get into the details of what I want to talk about today. The first one is this NIVs, that is non-immigrant visas. In the immigration system, we have NIVs, non-immigrant visas, and we have green cards, immigrant visas. NIVs are temporary visas, and also they are limited in the type of work that you can perform with those visas. They are limited regarding the amount of time that in some cases you can spend in the United States in those visas. For example, you have an L1 visa for multinational managers. You can be here up to 7 years or 5 years, depending on what type of manager you are. H1B visas, you may have heard, those are always in the news for professional positions. You have 6 years limit. And then you have this type of limitations. By the way, the reason why the visas are named with letters, so you hear me and you hear your colleagues, O1, L1, etc., is because those visa categories correspond to the sections of the Immigration and Nationality Act and the Code of Federal Regulations, and they follow those letters. So section A, section B, etc. So you have A visa, B visa, etc. So that's where you have that. The second point here that I think is important to understand is that we have this idea, this concept of immigration status. So what is that? What is immigration status? Well, immigration status is what you are granted once you are allowed to enter the United States as a foreign national. So that moment when you come back from a trip abroad and you're in front of this immigration officer at the airport who says to you, welcome to the United States, what are you coming to do? That moment is a very critical moment, legally speaking. That is called inspection. And technically what you're doing, when you're asking that officer to let you enter the United States, you're applying for admission. So you're applying for admission, the officer will inspect you, and if you pass that test, the officer will let you enter the United States. And once you're in the United States, you now have immigration status. So that is what I mean by that. A couple of points, by the way, and I'm going to be bringing one of the points that I want to make sure I cover are practices and strategies. So as I go through these topics, I'm going to give you some of those. On this point of the immigration status, I want to talk about something that is really interesting. All of us here, I'm assuming all of you guys are in the United States. in the United States, you have protections. You have this thing called Fourth Amendment that it says, you know, the police or the government cannot just come into your property and ask you questions without probable cause. Here's the interesting thing. When an individual applies for admission in the United States, to the United States, that moment when that person is talking to that officer at the airport, that officer has a lot of power. That means that that protection of the Fourth Amendment that we enjoy once we are in the United States is not that strong at that moment. And that is the reason why any person entering the United States is subject to questioning. And the officer has the authority to ask you, what are you coming to do? Well, show me your computer. Let me take a look at your iPhone. Let me ask you. In fact, this may sound really intrusive to you, but guess what? When a foreign national applies for a visa at the embassy, they have to disclose their Facebook information and any social media. And think about it. If you were sitting in your house in the United States and the government comes in and asks you, let me take a look at your Facebook information, what would you say to that? But in the context of immigration, the government has all this power. So I think it's an interesting point that when you're entering the United States, you have to consider that. There's a really sad case that I teach that there was a green card holder who was coming back to the United States, and this person was inspected, and they unfortunately found child porn in his computer, and they took the computer away, and he basically challenged that under Fourth Amendment. He lost the case, and because the court basically came back and said that protection, not so much at the border. So I know that, for example, as a result of that, a lot of companies have policies on this. When an executive is traveling internationally, they usually are advised not to travel with a device that has private or confidential information, because if the officer takes that away from you, it's going to be a pain to get it back. So I think important to keep in mind that point. Okay. So the next thing I want to talk about is these documents that you have to become, being an immigration practitioner is like speaking a new language, in my opinion. You learn all visas and all that, because immigration lawyers, we kind of use short names for things, and we use letters for visas, and we use form numbers for many things. So let me introduce you to some important critical documents that we have to deal with. The first one here is what we call an I-797 approval notice. So what is that? I give you samples of that in the handout so you can take a look at those later. There's a few things I want to tell you about that. The I-797 approval notice is a document that is issued by USCIS, and that document confirms that your client or your foreign national has been approved under a visa petition. So that is a part of the process that I'm going to show you later, but that document is an approval notice that confirms that your client has been found eligible for this type of visa that they apply for. So that is the meaning of the approval notice. Now, one thing I want to ask you to do after this presentation, because you have the sample, and probably you have seen this document from your clients. Here's the part that drives me crazy. I told you earlier that under the system that we have, our visas approval are employer specific and employment specific, okay? Here's the interesting thing. When you're looking at an I-797 approval notice, you are gonna find, in most cases, the name of the sponsor employer. So you will know if that approval notice was issued as a result of a work visa filed by Apple, Google, you name it. But here's the interesting thing. That document doesn't tell you what type of employment the person is authorized to perform. So that I-797 that the software engineer gets will look the same whether the person is a software engineer, the president of the company, an actor, a director, an electrician, or whatever the person is authorized to do. And that is something that is actually, I think it's a problem. I mean, I wish the government would do something about that, but they haven't done that. It's a problem because a lot of people get confused with that. And they get the approval notice thinking, oh, now I can work in any capacity for anyone. And as you now know, that is not true. So that is something that I think is important to keep in mind, approval notice. So you have a sample of those, take a read later. Next one, visa. When you hear someone, an immigration lawyer telling you, oh, send me a copy of your client's embossed visa, this is what we mean by that. An embossed visa is put in someone's passport and looks like this. Now, what is the meaning? What is the use of a visa? A visa, I think the easiest way for me to explain that is the ticket that you must have to enter the United States under the appropriate category. And here's what I'm going to begin to give you the exceptions to the rule, because this is how the law works. So the visa is required. I would say that generally a visa is required unless there are a couple of exceptions to that. One situation is for what you may have heard, people who are traveling to the United States under the visa waiver program. You may have heard, oh, I have a visa waiver. I have ESTA. Well, what does that mean? Well, here's how it goes. The visa waiver program is a program that started as a pilot many years ago. And that is a program that allows individuals from certain countries, mostly European countries, like the United Kingdom, for example, people from those countries who are citizens of those countries, who have passports from those countries, are able to get on the plane without having to get one of these visas if they're coming to the United States for business or pleasure. So the UK person who's coming to attend a business meeting or coming to Disneyland, that person doesn't have to go to the embassy and get a visa put in her passport because they are visa waiver eligible. The ESTA thing that you have heard is a registration that they have to comply with, I believe, at least 48, 72 hours prior to traveling to the United States. Is done electronically. I believe it's valid for a year or two. Everybody from the United Kingdom or any visa waiver country always should be on top of that. And they should make sure that they always have an ESTA registration valid and a valid passport in case they need to travel to the United States. So that is the visa. Now, I told you there were two exceptions. So that was one. The other one is Canadians. Canadian citizens, they have these breaks under the law that are very unique to Canadians. And one of those is the fact that a Canadian citizen is visa exempt. But this is what that means. That means that a Canadian doesn't need one of these. But here's the difference. The Canadian doesn't need a visa for any visa category. So if you get that Canadian client an O1 approval notice, that Canadian person doesn't have to go to the embassy and get a visa. They can basically get that I-797 document on their hand, and they go to the airport and they can come to the United States under that O1 petition. Now, if you're dealing with a non-Canadian who needs an O1 petition and they come to work under the O1, that person will have to go to the embassy, get a visa put on their passports, and then they can come to the United States. They have to have that visa to enter the United States because that is the general rule. And I just explained to you the exceptions to that rule. Now, I want to show you, I'm going to share with you a couple of things here. I'm going to put these two shortcuts in the notes right now. Let me put them right here. Okay, I put a couple of, there are two separate links. And one of those is how you download your I-94 document that I'm going to tell you in a second. The other one is a really useful bookmark for you to keep. That tells you the visa waiting time for any embassy around the world. And I have been following this for the last few years, and it's all over the place. I mean, during the pandemic, it was very difficult to get a visa appointment because embassies were closed. And the numbers are going all over the place. I have been following London closely. There was a time where the embassy in London said that it will take you like 200 days to get a visa appointment. The last time I checked a few days ago, I think it's down to 70 days or something. Here's what that means to you. Immigration processes take time. Planning is of the essence. You gotta talk to your clients. You have to make sure they understand the nuances of the process. We are not in a world where someone calls you and says, I need a work visa, I need it in a week, get it done. It's not gonna happen. Okay, so keep that in mind. So we have the visa here. I share with you the website. Again, the visa is necessary for the person to enter the United States under the appropriate classification, and you have to have it. One more thing that I think is important for you as to help your clients. Always make sure that your clients have documents that are valid, meaning make sure they have a valid passport for a while. Make sure that if they have a visa, that visa is valid so that you don't have to be rushing to the embassy at the last minute trying to get a new visa. So these are the type of things that how you can help your clients here. Make sure that you track these documents, and they always have valid documents so that you are ready to help your client get a new job if they need to do that. So that is the visa. I give you the website and all that. Okay, so the visa is issued by the Department of State, embassies, or consulates. By the way, that takes me to another characteristic of immigration law is that immigration, we are dealing with many government agencies. I mentioned already USCIS. USCIS is going to give you the I-797 approval notice. When the I-797 approval notice is issued, now you take that, you go to the embassy, and you apply for the visa. The officer looking at that part of the process is from a different government agency, Department of State. And each one of these government agencies, by the way, they have their own rules, they have regulations, they have, I'm gonna share with you a few from the Foreign Affairs Manual that is part of the Department of State. If you're dealing with USCIS, they have policy memos, they have rules and all that. So each one of these government agencies, different rules, sometimes they are not aligned, and that is what it gets interesting. So visa, right here, you have the sample of that. The next document, I-94, what is that? When I was telling you earlier that the foreign national applying for admission is gonna be in front of this officer, the result of that admission is gonna be the I-94. The I-94 basically is the most important document that your client will have while they are physically in the United States. There are two pieces of information that you always wanna make sure that you know. What visa category your client is, and what is the expiration of your client's I-94. If your client is admitted under the wrong status, that will be a problem. If your client is admitted and is given a wrong expiration date, and mistakes do happen, and they're painful, you gotta make sure that you always keep an eye on this. Because if your client overstays their I-94 by 1 day, the law is quite harsh. There's a section, if you want to impress your immigration law friends having a drink, tell them, what is this 222G thing? The 222G section of the INA is basically a rule that is quite harsh. It says that if you overstay your authorized period by 1 day, in this case, the screen, I'll give you a sample. This person is authorized to be here until August 31st, 2022 in O1 status, okay? If this person overstays by 1 day, so the person forgets about this I-94 and calls you the day after August 31st and says, lawyer, agent, I forgot to tell you, I was so tired. I just realized that my I-94 expired yesterday. Bad move. 222G means that now that person is out of status. That means the person's ability to go to the embassy now is gonna get a little complicated. Any visa that they have in their passport becomes void, no longer used, even if it's on its face valid. And that means that now in the future, every single time your client needs to apply for admission, goes to the embassy, they're gonna have to disclose the fact that they have now violated immigration law by overstaying by 1 day. So this is something important to keep in mind. I also share with you the I-94 website. That is where you download the I-94 for your client, or your client needs to do that, and you can keep track of those. Every time your client comes to the United States, they get a new I-94, and you have to always make sure that that is in good shape. Okay, so we have government agencies, documents, and all these things. Here's my way to put together those things. So this is kind of the flow of how cases work in immigration. The foreign national talks to the employer, maybe a production company. You as the lawyer, you are representing your client, trying to get them a job through an agent or something like that. You get an immigration lawyer who's going to be putting together these documents in a petition that they file with USCIS. USCIS reviews the case, hopefully approves the case. It takes time. Then if your client needs to go to the embassy, they go to the embassy and get that visa on their passport. Once they have the visa, they enter the United States. CBP is another government agency. That officer at the airport is part of Customs and Border Protection. They review everything. And if your client is successful, they get the I-94, and then they begin to work. And I like to put here the I-9 compliance because that's pretty fun. I-9 compliance is really cool. It's a section of the immigration law that deals with I-9 forms and the IRCA law of 1986. Fascinating topic, but probably all of you know about that. Okay, so the other thing I want to point out here is that when you go through this process, it takes time. And also you're dealing with different government agencies. As you go through the process, you get different documents that are going to be issued to you as a result of that. Oh my God, I can use my finger to point out to each one of those. Look at that. So I feel like a weatherman right now, 70 degrees in California. Okay, so you have the approval notice here, the visa, and the I-94, and you have to keep track of all these things so that your client is in good shape. Now, that's the process, the big picture of the process. Okay, now let's transition to, that is the process, concepts, all these things that you need to know. I want to focus on 3 types of visas. there are many more, alphabet of visas, they call it, H-1Bs, I mentioned that already, L-1s, managers, executives. I want to talk about these three ones because these are really important, in my opinion, to entertainment, And I love to talk about the B1 visa because I think it's fascinating and it's really interesting. I just think it's cool. So let me start with that. So B1 visa. So visitors for business. So there's actually two types of B visas, the B1 and the B2. B1 is for business, B2 is for pleasure. And the way how I remember that is because in the United States, we make money first and then we have fun. So business before pleasure. That's my way to remember that. So the B1 visa, visitor for business, is a visa that allows a foreign national to come to the United States to do something that will be permissible on the visa because it's not considered local employment. What I just told you is kind of the executive summary of what that visa classification allows. But it gets really difficult because how do you determine whether some activity that is happening in the United States is local employment? When they wrote these rules, which is probably more than 50 years ago, we didn't have what we have today. They were not even thinking about the possibility of for all you know, maybe I'm sitting in Italy right now. I'm not in Los Angeles. Maybe you guys are sitting in many places, Spain or something like that. So we didn't have the technology that we have right now. So the challenge, which in my opinion actually makes practice of this area very interesting, is the rules are outdated and we have these new technologies, new businesses, that new ways of doing business that were not clearly addressed by these rules. So I think it's something really important to consider. Okay, so the three things I want to tell you about the B1 visa. Number one is this matter of Hira. All of you remember the days when you went to law school. I gave you a copy of that case. That is the seminal case in this area. So the matter of Hira is the case that is actually quoted in the Foreign Affairs Manual as the seminal case. So what is this case about? Matter of Hira is a case of a company that made suits for men. And think about this, the suits were made in Hong Kong. The company was a Hong Kong corporation, and they had an Indian national they sent to the United States to meet with clients, to measure the clients and the measurements. And think about this case was decided over 50 years ago. So the advertisement was done not on the internet, it was probably done by mail. A client in the United States will order a suit, and then this guy, Mr. Hira, will come over, meet with the client, measure the client, send the measurements probably by mail. I don't think that we even have fax in those days. Maybe by mail. The measurements were received at the factory in Hong Kong, and the suit was made in Hong Kong. And then Mr. Hira will come back to your office and measure the suit to make sure the suit was correctly done. Somehow this guy got in trouble and he was put in deportation proceedings, or now it's called cancellation removal. And his defense was, he said, I haven't violated any law. I was legitimately here. Anything that I'm doing is fine. The court goes to the analysis of all the factors. And the lesson from here is, if the person is in the United States and is receiving remuneration from a foreign source, that is one factor that the court considered. The other factor the court considered was the fact that the suits were made in Hong Kong, not here. And finally, the court also looked at to exactly what Mr. Hira was doing. He was gathering information, gathering data, what some people describe as the input-output situation. He came to the United States to get input for some output that was executed out of the United States, and the suits were made out of the United States. Based on the totality of the factors, the court concluded that Mr. Hira didn't violate immigration law. What I just described to you is the guidance that we have to make sure that we understand any situation and advise our clients whether someone can be here as a visitor for business or not. So as you can understand, this can create a lot of uncertainty because there are some activities that, how do you treat that? Is that local employment or not? So that takes me to these Foreign Affairs Manual notes. And the note that I want to point out to you is a note that is challenging for the entertainment business. You have it on the screen right here. What this note basically says is that if you're a professional entertainer, even if you are not paid, you may not be able to come here as a visitor for business because of this rule. Take a look. Now, when you look, and by the way, I decided to give you the whole section of the Foreign Affairs Manual because I think it's really interesting. You're going to find a lot of really interesting situations there. And that Foreign Affairs Manual is what's going to help you advise your clients in these situations. But this note, in my opinion, is problematic because of the fact that it's very rigid. It basically says, once you are a professional entertainer, you cannot come here as a visitor. You have to get a work visa. And by the way, what drives me crazy is that the rule says, the note says, most cases will be a P. Actually, it should be an O because the O visa is more appropriate. P visa also applies, but the O is going to be better. So you're probably thinking now, wow, how can I then find a situation where I feel comfortable that a professional entertainer can come here and be legitimately as a visitor for business? That is when you have to look at the facts. For example, I think that if you have a client who is coming to the United States to attend a premiere of a movie, the red carpet event situation, your client is coming here, they're going to be walking down the red carpet. Maybe they will give a passive interview. They are being asked, you know, how's the movie, etc. I think if that is a passive interview, walking down the red carpet, you're probably going to be fine because I think that that is not local employment. Let's say that now your client needs to come here and they now need to do a press junket event situation. A press junket is when a production company secures a location and they invite all the press people to come here and interview the cast and crew for the movie, for example. That is a press junket, I understand. Interestingly, some practitioners think that that is local employment. Some practitioners think that that is not. A lot of gray area here. What about a person who's coming to the United States to attend a business meeting and they're coming here to report on a production that is happening out of the United States? I think that would be kind of, you're probably thinking already, that looks like, smells like matter of Hira because the movie is made abroad. If you were thinking like that, that's exactly what we immigration lawyers will be thinking like. We're going to try to find ways to take a look at the fact pattern and see if we can make the argument under matter of Hira. And if we feel comfortable with that, then we will advise our clients that they could come here as a visitor for business. So that is how it works. There's more notes in the Foreign Affairs Manual, fascinating stuff. You can find notes about photographers, even also notes regarding amateur performers and all that. Now, the other thing that is interesting in this context of the B1 visa and all that is the situation with influencers. And I also gave you a Foreign Affairs Manual section dealing with the I visa. The I visa is really interesting. The I visa is a visa that applies to journalists who are members of non-US news organizations. So think about a person from the BBC who needs to come to the United States to cover election. You know, it's actually news coverage, and the person is employed by a non-US entity. That person probably will qualify for an I visa. What I think is interesting is that influencers, and by the way, influencers is fascinating because it's so hard to determine whether the activity they are performing is local employment or not, because influencers basically, they are paid for being, period. And that is what makes it really hard. So the influencer situation, I think, is interesting. I have talked to practitioners who they have been comfortable with influencers coming to the United States to do certain things because they were able to argue that that was not local employment, because maybe the final product was completed abroad, etc. I also have seen practitioners who tell me that they feel more comfortable getting the influencers an O visa because that will give them more flexibility. So basically, the practice in this area is going to be, you're going to look at the fact pattern. You're going to have to determine whether this person needs a work visa or not. If the person could come here as a visitor for business, then you allow that. But if the person needs a work visa, then you have to get them a work visa to do whatever they need to do in the United States if that activity is local employment. You're probably thinking now too, what about this television production when you have a crew of people who need to come here to film? Take a look at these notes and the notes from the IFAM that I gave you too, and you will find out that that will probably require a work visa. They cannot just come in and film. They're going to have to get a work visa for that. So fascinating stuff. B1 visas. Okay. Now, let's talk about what if you now are looking at the situation, your client is telling you, I need a work visa because I'm coming to work as an actor, director, anything. What type of visa am I be looking at? In the entertainment field, O1 visas are big because the O1 visa category is fascinating. It's really broad. You actually have three types of O1s. You have O1s for the arts, you have O1s for motion pictures and television, and you have O1s for athletics and business and other things. They'll have three separate classifications of O1s. And each one of those has a different legal standard. I gave you a handout. What I did was I put together the regulations for each one of those and I put it side by side. When you read those, you're gonna be thinking to yourself, which one is the most difficult to get? Most people agree that the most difficult to get is gonna be the one in the fields of science, education, business, or athletics. The reason why is because when you look at the definition, by the way, what you have on the screen and you have the handout is actually the regulation definition, it's the law. I didn't make this up. You have to be extraordinary to qualify for an O1. You have to have extraordinary ability or extraordinary achievement. Now, how do you determine which is the applicable type of O1 for your case? That will depend on the background of your client and also will depend on what the person will be doing in the United States. So for example, if you are representing someone who is an athlete and the athlete is coming to the United States because now the athlete is going to make an appearance on a television show, that's going to be a kind of interesting case because you're going to have to decide, your lawyer is going to have to decide whether to file the case under the O1 science or athletics or the O1 for motion pictures. Probably the best move will be to file under the motion pictures type of case. But these are the nuances that your lawyer will have to deal with. So this question of how to file the case is critical because if you file a case and you are limiting the approval to one particular occupation, let's say you file the case for your client to work as a writer, and then now the writer wants to act, that's going to require going back to immigration and getting a new approval. So these are the type of things that are important for you to talk to your clients and get information on that. Each one of these criteria is more difficult. Most people think that the science, education, business is the most difficult one because not only because of the language of the requirement here, but also because when you look at the criteria, it's the one that says to qualify for this visa, you have to have either an award such as a Nobel Prize. No, I'm not making that up, Nobel Prize from the law, or you can satisfy at least three of the following. So because of that language, most people think that is the most difficult to get. Most people agree that the easiest, quote unquote, easiest is the one in the arts. And the one in the middle is motion pictures and television because of the language. All these cases are built up based on evidence. Everything is about printed evidence. You have to show to immigration that your client has achievement. You have to show that your client has recognition in the field. And you cannot build that up only based on letters of support. I get that all the time. Oh, I can get you 5 letters from Steven Spielberg to whomever. No, you gotta have some press, some articles that support the fact that your client meets the criteria. And if you get letters of support after that, I will help you. But you cannot make a case just based on letters of support. You have to have that evidence. And immigration reads those rules very strictly. If the rule says that your client has to be a member of has to perform services for organizations of distinguished reputation, that's plural. So you have to show at least 2. That is the level of detail and nuance that immigration is applying in this case. And I have to say, for the last few years, practice has been going, immigration has become very difficult with these cases. I get requests for evidence. Believe me, I get requests for evidence that I sometimes wonder, was the person really reading my case? They didn't realize that I have provided evidence already. It's quite frustrating and takes me back to the fact that these things take time. You may have a very strong case and you get an adjudicator who says, I want to see a copy of the diploma or the award. And now you have to respond. It's going to take time now. So preparation for these cases can take time. And the better you prepare the case so you don't get a request for evidence, that's the best. But you never know. You can always get a request for evidence. I have seen that for even cases that I will feel quite comfortable, the person is qualified and immigration will come back and ask for more information. So that happens. That is what we do. Okay. I want to tell you about the process too for O1s because it's kind of unique in some way. The O1 process requires, what you have on the screen, you can review that later. It's kind of similar to what I showed you earlier. But one thing that is in the middle of the process is this requirement for cases that you file in the motion pictures and television field. You have to always get an AMPTP consultation. The AMPTP is the Alliance of Motion Pictures and Television Producers. And you have to get a consultation from the applicable union or peer group for whatever you're filing for. So if you're filing for a writer, Writers Guild, director, DGA, actor, SAG-AFTRA, etc. So that is an element and requirement in these cases that is quite critical. You gotta get those if you are trying to get an O1 for motion pictures and television. The regulations require that. If you fail to do that, immigration gonna give you an RFE. If you fail to do that, you may have a case that actually maybe not be okay for your client to work in the motion pictures and television production. So these are the details that your lawyer will have to consider and tell you in these, again, additional steps that take time. When I tell you that the typical processing time goes to 4 to 8 weeks, you may have a 4-week case. By the way, the timeline begins once you give everything your client, your lawyer needs to prepare the case. Once the case is put together, the 4-week timing, in my opinion, is going to take you maybe a week to prepare the case. Maybe you take a week or longer to get the consultations in place. You file the case and you get lucky and the case is approved in 15 calendar days. If you pay extra fee for the premium processing, that's about 4 weeks. And maybe you're dealing with a Canadian who doesn't need to go to the embassy. So that will be a 4-week, situation. If your client needs to go to the embassy after this case is completed, you have to consider the fact that the embassy may not be open for interviews, or maybe you have to wait for weeks or months. These are the things that you have to talk to your clients. They have to understand the timing in these cases. So that is the process overview for the O1. These are a couple of more topics I want to cover here, the O2 visas and the agency O1s. So what are O2 visas? Here's the O2 visas. O2 visas are not standalone visas. You have to have an O1 so that you can attach an O2 to the O1. And the O2 visa is for essential support personnel. So you think about a situation where you have a director who tells you, a foreign national director who qualifies for an O1. And the director says, I am coming to the United States to work and I have to bring my DP. I have to bring my producer. I have to bring this team that I know because they have worked with me for many movies in the past. That would be a good candidate for an O1 or 201. So the director will be the O1 and the DP and the other people can be O2s attached to the O1. Now, the other thing that is really interesting in the O1 visa category is that if you're dealing with a television or motion picture production, you can also build an argument for an O2 if you can establish that based on continuity. So if you have a production that is beginning in the United Kingdom, for example, out of the United States, and the production is coming to the United States, it would be kind of not cool if immigration doesn't let you apply visas and get visas for that team that has been working together with the O1. That will be a good example for the O2 use. And, many practitioners have used that many times. I have had situations where actually I have been in meetings at the beginning of the production when I have to tell my client, look, if you need me to get visas for these people, you got to start shooting abroad. So I can build the argument for continuity based on that. And that is how I have been able to do some of those visas. So that is the O2 visa. It's really interesting, really a good practice, a good option to keep in mind if feasible. The next one is a very interesting topic. I love it. It's fascinating. Agency O1s. When I told you earlier that the general rule is that when you get a visa approval, you can only work for a specific employer. Here's an exception. Agency O1 petitions are petitions that, if properly drafted, would allow your beneficiary, your client, to work for multiple employers. There are actually a few types of agency petitions. There's the agency petition for an agent acting as an employer. There's an agency petition for an agent acting as an agent for a foreign employer. So let's say that you have a production that is being shot in the United Kingdom. Everybody's employed by a UK corporation. And when they're coming to the United States, they will remain employed by the UK company. That will be a case where an agent, a US agent, will have to file a case acting as an agent for the foreign corporation. And there are reasons beyond immigration why that is necessary. Maybe taxes. You always need to check with tax. Also with labor relations, because sometimes the signatory of some collective bargaining agreement has to be some company. So these are things that you also have to consider. And the other type of agency petition is the one that is an agent for multiple employers. I gave you also the policy memo from immigration, FAQs regarding agency O1s. my point here is quite simple. If you want to help your clients have maximum flexibility, get them an agency O1 and get an agency O1 that is properly drafted so that it's clear that any activity, any occupation that you anticipate your client will perform will be covered by that petition. And that way your client will be happy and will be able to work. And by the way, that became so important during the pandemic because embassies were closed, so people were not able to get new visas easily. USCIS was also taking a little longer than usual. So during the pandemic, it was a time where a lot of people would come to me and said, who do you think has the best chance if we cast someone? And I said, look, if you have someone who has an agency O1 that is clearly an agency for multiple employers and covers the type of services, that would be a good candidate because if that petition is fine, the person is ready to work. Or the other one would be Canadians because Canadians don't have to go to the embassy. So you can also get the visa approval and let them come in. There was a little challenge with that at the beginning because of the entry bars that you guys probably saw, but that is another example of the advantage of that. So that is O1 visas. Okay, P visas. So the P visa category is a category that I think is also interesting because there are actually 3 types of P visas. And I gave you a little chart that I put together with the criteria, the requirements and all that. The couple of ones that I think are interesting is there's a P3 visa that applies to culturally unique performers. And that would be a situation like, for example, let's say you have a client who is perform some type of music maybe that is culturally unique, maybe is folklore from some country. That may be a good candidate for that P3 visa if the person is coming to the United States to perform that culturally unique act. That would be a P3 visa to consider. The other one I think is interesting is the P2 visa. The P2 visa is a visa that applies to different types of reciprocal exchange agreements. And the one that I always use, not always, but a lot of times I use, is the P2 visa when there's an agreement between ACTRA, which is the Canadian sister organization of SAG-AFTRA. So if you have a performer who is a member, it has to be a Canadian citizen, who is a member of ACTRA, and the person is coming to the United States to perform as an actor in a SAG-AFTRA cover type of production, you may be looking into the P2 visa as a good alternative. Now, the beauty of the P2 visa is that it doesn't require the level of achievement that the O1 requires. So if you have a P2 case, whether the individual has extraordinary achievement or recognition is irrelevant. You only have to show the person is a member of ACTRA and the person is coming to perform until the SAG-AFTRA ACTRA agreement, and then you have your P2. So I think that is a really good option for that. I believe there's also a P2 agreement between the Actors Equity of the United Kingdom and the Actors Equity in the US. I haven't done that in a while, but that's another option for that. The P1 visa is another one that applies to individual performers or a group. So you may have a P1 group, you have a internationally recognized group. It could be a music, it has to be more than one person. It has to be at least 2 people performing together. You may be looking into the P1 visa too. I have seen a lot of practitioners who get P visas for bands. I also have seen practitioners who get the P visa for Cirque du Soleil and those type of performers or theater, something like that. So I have seen that too. And that is the P1, P2, and P3 visa category. And you have to get consultations. You have all the information that I share with you. And also you can have this, it's similar to the O2. You can have the P1S, P2S, P3S. That will be for the support personnel for the P1. So if you're bringing a band and you need to bring the sound engineers for the band, that will be a good option to consider. So you can look into that too. And my gosh, I have time for questions. 9 minutes for questions. So here's my little doggy, Finny, who came with me wine tasting recently.
So sleepy.
He's sleepy. He had too much wine. So I'm ready for questions. I can stick around for a little bit.
Okay. I don't see any questions in the chat, but I had somebody ask me recently, if they have an I-94 that's expired, right? And then they in the interim got an approval for another immigration status. do they need to then get a new I-94?
Well, number one, is this really an expiration date or was a mistake by immigration? Because
it was an expiration. It was on their first O1, and then they got another, I think another O1, and then, you know, and so they were sort of freaking out because they were like, had heard the I-94 is the, you know, is the thing, because also because one time they got lucky in the I-94, they made a mistake and gave them, you know, 60 extra days. And so no one was correcting that.
If a person overstayed the I-94, the problem with that is that number one, the person has to leave the country right away. There's a 180 day and the 365 day. If you overstayed by 180 day, I believe if you leave the country and come back, you're subject to a 3-year bar. And if you overstay for more than a year and you leave the country, you're subject to a 10-year bar. So any overstay between 1 day and 180 will not trigger the 3-year bar. But the problem with that is that when you go to the embassy, number one, any visa that you have in your passport becomes no longer valid, even if the visa on its face is still valid. So that means that if you're coming back to the United States, you have to go back to the embassy, apply for a visa, and you're going to have to disclose the fact that you overstayed. Now, that doesn't necessarily mean that you're toast for the rest of your life, but you have to explain that and, you know, deal with that. You're going to have a really good lawyer to help you at that moment. One thing, by the way, I learned recently, minors, you know, there's some breaks for minors. Like if a minor, you know, overstays, it's not as, the rules are not as rigid as for adults. I mean, I just saw a situation with a minor recently where I didn't know that, so I learned that. So that's that. But yeah, you're right. I mean, the best thing you can do for your clients, don't make sure you put the fear of God on them and tell them, pay attention to those dates so that doesn't happen. I mean, it's the death penalty in immigration, basically.
We have another question. If you come in as one category under motion picture 01, and then they want to work in another category, for example, writer to actor, what do you physically have to do? Does the visa on its face say the category you are in?
Yeah, so if you, number one, if you got an O1 in the motion pictures and television field to work as a writer or an actor, for example, and you got approval for that, and now you want to write, there are two ways to handle that. You can file an amended O1, basically telling immigration, you gave me an approval for this person to work as an actor, and now I want this person to work as an actor and writer. And to do that, you have to go back to immigration and you have to get a Writers Guild consultation and a new AMPTP consultation. That will be one way to do that. The other way to do that could be to file a concurrent O1 so that you now have this O1 for writing and O1 for acting. I mean, I don't know why you will do that, but technically that's another option for you. But the point is, for that additional employment, because it's outside of the scope of your O1, you gotta get approval from immigration. That is how it works.
Is there a risk if you file an amended that they just they take away the first one?
Yes, there's a risk for that. But in my opinion, I think that if you're filing an amended one, I think that you're in a better shape to do that. That is, you go back to immigration with a brand new petition. And my thinking is quite, I mean, I have no reason to think about it other than logically, I'm thinking an adjudicator looking at the case probably is going to be more persuaded to approve the case if you're simply asking for an amendment versus if you're coming brand new and saying, oh, now I want to be a writer or something like that. That's my completely personal, based on no science opinion. You know, I may be wrong with that, but that's that.
I mean, because technically you could have 500 different O1, like one person can have an unlimited number of different O1.
Yeah, that's actually a good point, because that is actually the example when I explain this concept is, let's say that your client is a super famous actor who is working for HBO, for Netflix, for Amazon, and for Disney Plus. You can do that in two ways. You can have 4 petitions for the same actor working for each one of these shows, or you can get an agency O1 that covers everything, and that gives you maximum flexibility. So that is those are the two options. You can have multiple O1 visas for multiple productions. And by the way, that is why keeping an eye on the validity of the visa is important, because the example I just gave you, that person will have 4 I-797s, one for HBO, one for Netflix, one for Amazon, one for Disney Plus. But to enter the United States in O1 status, they have to have one O1 visa that is valid, okay? If they have a valid visa, they are good to go for each one of those productions. That became critical during the pandemic. I have so many cases where people came to me and said, we want to cast this person, but we just realized that the visa expired last year. And that's what I have to say to them. Look, this is going to be tough because now good luck getting an appointment to get a visa is hard. I mean, not impossible. I mean, the embassy have been helping with some emergency cases, but you cannot count on that. That is a challenge with that.
Playing that embassy game is not fun, and begging and cajoling and stalking them.
And when we have the entry ban and we have to get these waivers, I don't know if you follow that news, but it was, I'm pretty sure some of the attendees maybe were working on that. It was a nightmare. We were getting waivers for people. You have to get them to the Department of State and all that. It was pretty tough. And the challenge I saw was that it was very, you were at the mercy of the government trying to convince them that this was an emergency. And, you know, that's tough, you know, especially when you have, I mean, everybody attending this, I'm pretty sure, tell me the producer, creative people who is happy with the answer. We may get you a visa, but we don't know if we're going to get you a visa. You need a person to show up to work on Monday, but I don't know if the person's going to be ready on Monday. That's not how the business works. And that's what
they don't like that. No one in production like that.
Yep, nothing. Okay,
another question. As of November 2022, it's my understanding that there will be an increase in the minimum requirement and salary for H-1B visa applicants due to Trump's bill. Is this going ahead, and where can we find the minimum salaries requirement?
Oh, H-1Bs. You gotta go to the ONET website and you can find the surveys and applicable surveys and salary figures for that. You know, I haven't been following that H-1B situation recently because I got busy with production, but I think you're right. I think it's gonna be a new rule. And the concern with that rule was that, for those of you who don't know what this is about, H-1B visas are for professional positions. And the way how those visas work is they are the most regulated visas in the world of immigration. You cannot move a person from one location to another one without having to do some paperwork. And the issue is that as part of the preparation of the case, you have to get a document that confirms what the minimum salary is, because you have to make sure that you are not underpaying US workers. So what this person is asking is, there's this rule that requires you to pay at least some salary. And under the last administration, there was this rule that they wanted to create that was going to increase the salaries for H-1Bs as a result of that rule. And I think that rule was put on hold because of litigation, and now it may come back. So that is the question. Quite honestly, I haven't been following that closely lately, but it's going to be a challenge if that happens.
Yeah. Okay, another question. We hosted a woman from Mexico with a visitor's visa who extended her stay, went home for holiday, was prohibited from entering, deported, banned from entering the US for 5 years. After 5 years, she still cannot re-enter. She tells me US Customs has added her to a ban based upon unreported income. What is the legal basis for extending the ban?
I don't know the answer to that. It's too factual specific.
Yeah, there's a lot of
but I can tell you a few thoughts on that that we cover actually. You know, a person entering the United States as a visitor for business is not allowed to get any remuneration from a US source. Now you know that because I show you matter of Iraq. A person who gets remuneration from a US source could be banned based on the fact that the person violated the immigration status. The length of the ban is something that I don't really practice in that area. I mean, maybe there's a rule that gives you some number of years, but I think it boils down to recognition of the fact that US immigration law, you are subject to decisions made by these officers who have a lot of authority. And, you know, you gotta be super careful with this and look at that. A person made a mistake and now is paying the consequences of that mistake years later. That is what every immigration practitioner takes these rules very seriously. I mean, they can ban, the government can bar you for years. And any person, think about it, if you have a person who is a promising newcomer, you know, an actor, director, or something like that, if the person makes a mistake and then they cannot come to the United States for the rest of their professional career, it's going to be tough. So that's why you have to follow this rule. Yeah, I'm sorry, I don't have a specific question for that.
But with regard to the visitor visa, the B1, right? So it's, if you're paid by a US company, that is definitely a no-no and will get you in trouble, but not being paid by a US company doesn't automatically mean it's okay what you did, right?
Exactly right. You're right, because if that were the case, then everybody will be doing this. I will create a company in Mexico and I will
in
have
Mexico and pay only through there.
That is what the matter of here lesson is, that you look at the totality of factors, and then you look at the foreign affairs manual, and then you basically have to analyze and say, am I comfortable arguing that this activity happening in the United States is not local employment? And sometimes it's a tough question. Sometimes it's a gray area. You know, a lot of lawyers will basically tell their clients, look, this is a gray area. I have to prepare you. What is your level of acceptance of risk regarding this? And some clients may say, you know what, I don't want to take the risk. I'd rather get a work visa. Or some clients may say, I may be able to work with this, but that will be between you and your lawyer, and look at the facts. You know, that's that.
Here's an interesting question. What's the best visa for someone wanting the flexibility of working, for example, as a lawyer and the creative arts like acting?
Well, those positions are so different that I don't know. I mean, well, for example, as a lawyer, if you're a Canadian or Mexican national, you can look into a TN visa. Okay. Right. For an acting, that will have to be an O1. Right. But here's the couple of things to consider. You cannot hold two immigration statuses like a TN and an O1. You cannot be that. I will find hard a situation where you could argue an O1 for an attorney, unless you're arguing that the attorney is, let me look, the attorney is
business, right? Or
business, but I think that will be a tough one.
No, that's hard.
Yeah, I don't think that you're gonna have a good way to do that.
Okay. I mean, I think the weirdest O1 that I've ever successfully was a life coach, but it's because she made so much money, I got her in as a business.
Yeah. I mean, that's another thing. Thank you for bringing that up. The O1 visa category is fascinating because it's so broad that you may have. One of my students became an expert on esports. She gets apparently you get money for playing sports in the computer. That
a lot of money.
A big industry. So she has become the expert getting O1 visas, or I think she uses B visas for them. So yeah, the O1 visa, you know, I was working in a case for an elephant expert for a zoo, you know, so that was an O1. You can have an O1 for a person who's the most experienced person taking taking cameras under the water or something like that. So it can be quite unique.
Yeah, and it's a very flexible visa.
Yeah, it's very broad, right? You know, because it includes the arts, you know, the fine art. What is that?
Right. And also business, like what is, you know?
Yeah, in fact, some of the
business of whatever business, right?
Yeah, some of my colleagues told me about the influencers. One of my colleagues said, I've been getting O1 in business for some influencers, because the influencers was an influencer in financial planning. So he made the argument and he was able to get an O1 like that. Yeah.
Okay, next question. The validity period marked on an NIV is usually about 10 years from the date of issue. Does it mean it can be used for multiple entries within this period, or in what circumstances would you need to apply for a new NIV?
When you're saying NIV, I'm talking about a B1 visa or something like that. Probably that's what the person meant.
Or O, I guess.
Yeah, what happens is there's something called visa reciprocity. That if you Google visa reciprocity, it's going to take you to the Department of State website. Each country has a different rule. So some countries will allow you to get a visa for a period of X number of years. So maybe what this person is talking about is that country happens to allow issuance of visas, a B1, B2 visa valid for 10 years. So the answer is, as long as that visa remains valid, the person can keep coming back and forth. That's what you have to keep an eye on, the expiration of the visa. That's a separate issue. And if that visa is valid, the visa could be used up to the expiration of that document.
Okay, next question. Does the O1 agency-based visa require a list of activities, and what happens if you want to add additional jobs?
Excellent question. There's actually a regulation that talks about that. The general rule is that when you have to add an additional engagement, you have to go back to immigration and get a new amended petition, unless your petition is an agency O1 and the additional engagement requires someone of O1 caliber. So in a case like that, the question is the additional engagement, does the additional engagement require someone of O1 caliber? If that is the case, the next question is it really an agency petition for multiple employers? Take a look at how the petition was drafted. Number two, is the petition services the type of services the person will be performing? If the answer to that question is yes, in my opinion, that will be okay. And what I do in those cases is I get a letter from the agent confirming that they are representing this person in connection with this engagement, and then the person works based on that. My point on that, and by the way, anyone who's interested in that, I co-wrote an article on agency once, and I actually share language that I think is important. Be clear about what you're asking. If your intent is for your beneficiary to work for multiple employers, spell it out. Say it. Put it right there on bold, so the immigration will approve the case, and there will be no question on that. What drives me crazy is if you are not drafting this correctly and you're kind of wishy-washy about, is this an agent for multiple employer, agent as an employer? Be clear. You will be okay. If you are kind of not clear because you don't understand the rules, then you're gonna create a problem for your client. So you gotta be really clear about what you're asking, so that there will be no questions later.
Okay, and then it looks like our last question, would a combined B1, B2 visa permit a longer period of stay than solely a B1 or B2? How long does that allow visiting the US in general?
I think the maximum period is 6 months, and you can come here. Actually, in the Foreign Affairs Manual, I think there's a note that talks about how you could come here for those two purposes. In other words, you can tell the officer legitimately, I'm coming to attend a business meeting this week, and after my meeting, I'm gonna take a week vacation and go to the parks or whatever. There's nothing wrong with having that dual intent, meaning business and pleasure. And the maximum period is 6 months. Now, if you enter under the visa waiver program, you can only be admitted for up to 90 days. And the difference, by the way, on that is that if you enter the United States under the visa waiver program, you cannot extend the 90 days. Once you get the 90 days, you have to leave the country. I came across an interesting situation at the beginning of the pandemic, March 2020, I guess. I got a call from a person who asked me, the person was here, didn't want to go back to Germany because remember those days, everybody was freaked out. And her I-94 visa waiver was expiring like a week later. And you would think that the government will come back with some rule that will give you some break. No, it didn't happen. I know that for a short period, the government allows some people to extend the visa waiver situation, but that was a unique situation. It was not something that was, I don't know if it's still the case. So that's that.
Yeah, I don't know. I haven't kept up with the visa waiver. All I know is I had a colleague who has 2 passports, one from Israel, one from France, came in on ESTA on the French one, but had a valid visitor visa on the Israeli one. And then he didn't tell us till after he did, after the fact, but he said, oh, my ESTA is expired, but I have a valid B1 on my other passport. But we're like, you can't do that. You have to come in with the visa in order for it to apply. You can't just have it be there.
One more thing that I learned, I didn't know this until a few years ago, is that in some countries, you can get more than one passport, like UK, I think. And that is a really smart move, because if you have a busy client who needs to, who's working all over the world, having 2 passports is a really good advantage. I had someone in that situation, and I was surprised to hear that.
Would they have 2 UK passports?
Exactly,
like one
right.
US, UK citizen has 2.
2 UK passports.
Oh, wow.
There's actually some rules in that country that allow you to do that. And that saved the day, because basically this person didn't want to, you know how it is. When you go to the embassy and you apply for the visa, the embassy keeps your passport. So that basically means you're trapped in that country, for a few days. So this person was so busy that he wanted to have the flexibility to leave the passport in one country, getting the visa, while he was going to another country. And that was great. So since then, I tell people, find out if your client can get an extra passport, go for it,
Right. Yikes.
You have more options.
The US would never issue that.
I don't think so. You're right.
No,
They even ask you to send the old passport to.
No, they would.
No,
Okay, next question. Can the visa waiver program be used for work as a performer?
No.
No.
The visa
Absolutely
waiver
not.
program is only for entry as a visitor for business. It specifically, if you did that, that would violate your status. And by the way, here's the next thing about that. If you violate your visa waiver status by overstaying or violating the status, that makes you ineligible to enter under the visa waiver. And that means that now you have to go to the embassy and apply for a B1 visa. And that means that when you apply for the B1 visa at the embassy, you're gonna have to disclose the fact that you violated your status before. So good luck to you.
Oh, I'm uncomfortable even with that question being asked.
Yeah,
like
no.
Okay, next question. As an Italian attorney qualified in the Italian jurisdiction and admitted at California Bar as foreign legal consultant, what is a type of visa which allows me to work in the US?
Some of what you have to find an employer that will have to sponsor you for a work visa. Probably going to have to be an H-1B.
H1, I was going to say
Yeah.
H1B, right?
Yeah, and the problem with that is that H-1B visas are not available all year round. And that means that you have to give it a try and maybe get lucky because it's a lottery every year. And then, you know, hopefully you get an approval. So that will be a professional position. It will be an H-1B. I doubt that. I mean, I doubt that an argument will be made for an O1 for the reasons we talked about earlier.
Hard.
I think it would be, you know, excellent.
Okay, I think that is all our questions.
Wonderful.
But what a great, oh, here's another one. One just popped in. What about an EB2 for a lawyer? Yes, that would be an option.
EB2, that's a green card case, isn't it?
Yeah.
Yeah, I wasn't planning to cover green card cases.
Yeah,
but
that's a whole other CLE that we can do.
Yeah. Okay.
And I think that is it. Thank you everyone for coming. And you will get your CLE, I think, either emailed to you, and it's also going to be in your portal if you're a member of the BHBA. And our section, the immigration section, has our next meeting on May 13th, and there will be something coming out about that soon. It's going to be that field trip type situation. But thank you, Fabricio. That was so interesting. I love it. I mean, I don't think I've ever heard anyone call I-9 compliance fun, but
I-9 and B1 visas. I love that.
It's so much fun.
So much fun. It's so much fun. Okay, thank you so much for the opportunity, and hopefully I cover everything that I said was going to cover and more. So
yes, and if anyone has questions, feel free to contact us through the bar organization or contact Fabricio through LinkedIn, and bombard him because I'm sure he's not busy enough.
Okay, thank you so much.
Okay, thank you.